Hello everyone, welcome to Telugu One Academy. Today we are going to discuss a topic called Armed Forces Special Power Act. In this class, we will be learning what exactly is Armed Forces Special Power Act and also look through the different model mains and prelims question regarding Armed Forces Special Power Act. So this Armed Forces Special Power Act 1958 was formed pre-independence era from the policy of Lord Linlithgow during the Quit India movement in 1942. But in post-independence, this act was framed in the year 1958. Prior to that, an ordinance was promulgated by the then President of India, Dr. Rajendra Prasad, to counter the insurgency in the region of Northeast India. So now, especially it was called then the Armed Forces Special Power Act for the region of Assam and Nagaland, or you can also call Manipur, Assam. Okay. So now what exactly was the Act of 1958? So the Armed Forces Special Power Act of Parliament gives the armed forces to maintain the public order in disturbed areas. So now we have to note two important points, my friend, that the act defines the disturbed area or not. Does the act define disturbed area or not? So my friends, the name disturbed area is provided within the act, but the clear-cut definition is not provided. And rather than that, this act also provides immunity to the armed personnel who are working in this region to control the insurgency from the acts committed under this act. That is, if a person kills a person on mere suspicion that he is doing insurgency activity or anti-civilian duties which disturb the order of the public, then that personnel or that armed personnel cannot be prosecuted. So same thing, it gives the armed forces the authority to use force and even open fire after warning a person who is found to be in contravention with law. And it also says about the disturbed area. As I have said you that the act does not clearly define what exactly a disturbed area. But who can declare that an area is a disturbed area under this act? Both the governor of the state on the recommendations or without the recommendations of the state government, and even the central government can declare an area to be a disturbed area under Armed Forces Special Power Act. Once that area is declared a disturbed area, then armed forces will take over the control of the region. But my friends, the act itself says initially, or the concern of the act is that it need to work in tandem with the civilian authority. That is, there is no replacement of civilian authority with an armed authority or armed forces. So it is in hand with the civilian authority that these armed forces should work at the ground level to control the insurgency activities. So under section 3 of the Armed Forces Special Power Act, the definition or the major concerns how an area to be, at what an area to be declared a disturbed area. That is, either it is ethnic clashes or religious clashes, whatever it is the case. It is a clear discretion of a governor or central government who can declare that an area to be a disturbed area even if it is in peace. The power to declare any territory was, I said you, with the central government. It was not at the start, but it went in the hands of central government with the amendment brought in the year 1972. With the amendment brought in the year 1972. Please note it down. Friends, if you do not follow my pace, please pause this video and note down the important points from the slide which I have provided for you. The act also allows the forces to arrest a person and enters and search the premises, and it also allows the armed forces personnel to destroy the buildings or infrastructure which is thought to be used for the purpose of training the insurgent groups and also to store arms and ammunition. Then AFSPA also protect the security forces from legal prosecution, I have said you, for the acts committed under this act. The act applies not only to the three armed forces, but it also applies to the paramilitary forces such as Central Armed Police Forces, which include some rifles. It also includes CRPF, BSF, and etc. Next, where exactly does this Armed Forces Special Power Act is applied in all? So, when you see this map, you can look at the areas where Armed Forces Special Power Act is under application. Especially you can see the concentration in northeastern region. But recently, in recent years, two states, that is Meghalaya and Tripura, have been removed out from the list. But Jammu and Kashmir also comes under AFSPA, but it has its own law, that is Armed Forces Special Power Act for Jammu and Kashmir. For Jammu and Kashmir, apart from Armed Forces Special Power Act 1958, this act was promulgated in the year 1990. We will talk about this more. So this controversial law, why it is controversial, my friends? Because the armed people who are stationed in those disturbed areas have immense power, and there were incidences where mistakenly or by will, sometimes, very rarely, that civilians were killed during skirmishes, or because of misunderstanding, or because of lack of intelligence report or mistaken intelligence reports. The recent incidents which happened in the Nagaland Mon district, where around 14 civilians were killed. Initially, it was only 6 civilians who were shot down, but later, because of the angry that rise because of the death of these 6 civilians, the protest rise, and eventually it also led to the killing of 7 to 8 more civilians. So such incidences happen. Apart from that, there are also incidences of rape or sexual assault on women of this region. We will see the famous incidences which happened on the sexual assault and how the public reacted on that. Okay. So because of this act has been a controversial and also called a draconian law or colonial legacy, which is continued in the post-independent world. So on that, this act is in the areas, you can see Nagaland is permanently, till today also, even Assam is on permanent. Manipur, excluding the municipality area of Manipur, okay, 7 assembly constituents have been excluded, that is the exact municipal area of Imphal, and parts of Arunachal Pradesh. Besides, it is also in Jammu and Kashmir, but it has been repealed in the region of Tripura and also from Meghalaya in eventual years. We will talk about this more clearly, okay, what was the exact year and date in the eventual slides. So, what was the history of AFSPA? As I told you in the starting of the class, that it was promulgated for the first time during the Quit India movement in 1942 to suppress the movement by Lord Linlithgow. So, it is an idea of Lord Linlithgow, Viceroy Lord Linlithgow. So why exactly do we need this act? Under which consideration? You know, my friends, even this act, even it is called draconian or controversial, this has been said by the Supreme Court that this act does not violate any constitutional provisions. Okay, Supreme Court has already said, yes, this act is fine, you continue with this act. So now how can you challenge? Why can't we challenge? Because of the Article 355, which tells, it is provided in the Constitution, Article 355, which tells that the central government has power, or it is responsibility to the central government to protect every state from internal disturbance. So Article 355 itself provides the authority to the central government to protect the state from its internal disturbance. Under this article, this act has been framed post-independence. So later during the partition, we see lot of insurgency happening, especially in the region of northeastern India. So during that time, various disturbed area acts were promulgated in that region to control the insurgency happening in the region, and these were the various acts such as Assam Disturbed Areas Act, East Bengal Disturbed Area Act, United Province Disturbed Area Act, and Bengal Disturbed Area Act, which provided the similar sort of protection for the armed personnel and special powers for the armed personnel. So why exactly the parliament had to place this law? Because, my friends, the public order and police is a state subject. State subject. But why exactly the center has to come in? Because when states look at themselves, or states are in a position that they can't control the insurgent groups or the public order in that state, they have approached the center for their helping hand. Since then, this helping hand has been continuing consistently. So when you see what exactly happened or led to this law in the year 1958, which is called Armed Forces Special Power Act, Assam and Manipur was the then Nagaland, which was a part of Assam region. Okay, so what happened in 1951-52? They did not recognize India as they did not recognize the elections of India, and they conducted their own plebiscite, which they say that 99% of the population of Nagaland want to be an independent Naga state rather being a state in the Union of India. So what happened? They started rebellion. They started a parallel government, which started as a small movement, went against the Indian Union's authority. So to counter this and also protect the public order in the region, this act was first placed as an ordinance, and next it became an act in the year 1958. So all this have been provided in this slide, my friend, whatever I have said you. Please try to pass and read it if you do not follow my speed. Okay. The federal government of Nagaland was formed in the year 1923-56. What about the Northeast insurgency? That we have a separate class where you can learn more about the Northeast insurgency in the region of Assam and all those. But why exactly the name has been shifted from Assam, Manipur to North Armed Forces Special Power Act is because the Northeast was later carved into number of states eventually in the years, like Arunachal Pradesh, first Union Territory in 1972 and a state in 1987, and later Meghalaya was formed in 1972 as a separate territory with autonomous territory powers, and Mizoram 1973 and Nagaland in 1957. So that's why the name has been later changed. And its territorial extent was also extended because of the division of the whole states. Next important thing, even the Punjab region, Punjab Chandigarh region was also had its own Armed Forces Special Power Act, which was promulgated by the Parliament of India in the year 1983. This is mainly because it was soon after Operation Blue Star and also rise of Khalistan movement in the Punjab region. Because of the proxies from the Pakistan region, the region was very disturbed, and to counter this and to maintain the public order and to maintain the Union of India, the central government promulgated an ordinance and brought whole the Punjab Chandigarh region under its control. But later this ordinance or this law was repealed. This law was repealed in 1997. Since then, this law was not placed in the region of Punjab and Chandigarh. So Punjab and Chandigarh also had their own disturbed area acts. Okay, they also had their own disturbed area acts. Eventually, those states also repealed their own disturbed area acts in the years to come. So I have provided the same information in this slide, my friends. Please try to pass and read it. You see here, in 2008, Punjab has repealed its disturbed area act, and subsequently in 2012, the Chandigarh has repealed it. Okay. Next is, as I told you, the Armed Forces Special Power Act of Jammu and Kashmir, that is in the year 1990. Even this act is in place till today, and the Jammu and Kashmir also had their own Disturbed Area Act, but this Disturbed Area Act of Jammu and Kashmir was later repealed in eventual years. The same thing. Why Jammu and Kashmir? As we know the reasons for Jammu and Kashmir, because lot of insurgency is going on, lot of proxy war from Pakistan side, lot of proxies from Azad Kashmir and Pakistan occupied Kashmir come into this. There is an infiltration. There is also cross-border terrorism going on there. Okay, fake currency coming in. So all these things, to counter all these things, AFSPA has been placed in even Jammu and Kashmir region. As I told you, Jammu and Kashmir had its own Disturbed Area Act, which was repealed in the year 1998. Okay, the same sections are almost provided in these acts also, but in this the powers or the security given to the armed personnel, that is, they can't be questioned for their acts done under this act, is provided in section 7, where it is in the Armed Forces Special Power Act 1958, it is in the section 6. Now, let's see some of the important sections or provisions of Armed Forces Special Power Act. That is, section 3 of Armed Forces Special Power Act is to be noteworthy because it mentions about the disturbed areas. But the major controversial in this section is that the section does not define what exactly is a disturbed area or how you are declaring an area to be a disturbed area. Thus, a mere suspicion that there might be an insurgency or mere want of political needs by the difference in government in central and state could also lead to declare an area to be a disturbed area. So this is a controversial thing. But most of the times, the government does not go for such thing, but only to protect the civilians. State opinion. See, as I told you, in the year 1972, with an amendment to the Armed Forces Special Power Act 1958, the power to promulgate has been also given to central government. Thus, whenever the state governor or state government says, no, not needed, we are very peaceful, then the central government can override the authority and promulgate the disturbed area under AFSPA 1958 in the region. When the act came into force, as I told you, the governor of the state only, in 1972 it was given to the central government also. See, as I told you, it does not explicitly explain what exactly is the disturbed area. Only requires such authority to be opinion that whole or parts of the area are in dangerous or disturbed condition. Such use of armed forces in the aid of civilian power is necessary. So next thing is section 4 of AFSPA. This says what all the things that armed people can do in the region where AFSPA is promulgated. That is, powers granted to the security forces stationed in the disturbed areas. So now what all they can do? They can shoot down a person with a mere suspicion by giving a due warning. They can go and search without any warrant. Okay, they can go and search without any warrant. If you observe all these conditions, my friend, you can see there are major lack of human rights and the basic fundamental rights also. One can note down what are those fundamental rights from these given acts. Let me explain you. An individual who is committed a cognizable offence or against whom a reasonable suspicion, just a suspicion, she or has committed about to commit a cognizable offence can be arrested without warrant. This is against Article 20, right against being arrested. Against Article 20. This can also be said against Article 4, right to life and personal liberty, that is Article 21. And maybe such force is necessary in order to carry out an arrest. And even you see, if he is in opinion that in order to maintain public order, necessary to fire upon or use force even to extent causing death, these are high words, against any individual who is deemed to be acting in contravention of any law that is in force with the disturbed area, prohibiting an assembly of 5%, this is section 144. Section 144, this is against Article 21, that is again right right to life and personal liberty. This is against that. This action can be taken after giving due warning that is necessary. But most of the time, this due warning is not given by the armed people and they directly jump into the action. They can even destroy the arms which were gathered by the insurgent group. They can even destroy the property where the insurgent groups have been trained and etc. with mere suspicion of sometimes. Even training camps, hideouts can be destroyed. They can even enter and search without any warrant. So this gives a lot of disturbance in the personal lives of citizens who are living in and around the disturbed area. So what exactly is the major difference between this Disturbed Areas Act, which I have been telling you continuously in the case of Jammu and Kashmir, Chandigarh? So these Disturbed Areas Acts are nothing but acts promulgated by the state legislature which says that state has power to declare an area to be a disturbed area. So here in this case, the power will exist only and only with the state government, but when it comes to AFSPA, the power exists with both the governor of the state. Please note down, who has the power to promulgate AFSPA? It is not the state government, but the governor of the state, and the central government has the power to promulgate AFSPA in a region. So that is the most important point. So that have been provided to here. Only difference is conferred as a power to state, but AFSPA is invoked either by governor or the central government. Next, let us now see some of the important famous protests happening against the Armed Forces Special Power Act. One of the famous protests has been taken over by the Irom Sharmila, who is also called Iron Woman of Manipur. So she was a woman who saw the atrocities committed by the armed personnel in the region of Manipur, especially with the incident of Malom massacre. So what happened was, then she went on hunger strike. Then army or police took over control over her, saying that she has been committing suicide on her, so we can't allow that. And from that day onwards, for 16 years, she have been fed forcefully through this tube, nasal tube, which goes into the nose towards the throat. She was forcefully fed for 16 years. She did not had any food for 16 years. Later, after 16 years, she saw that her hunger strike is no more useful, and she left that hunger strike and entered the politics. That is a different issue. But this is one of the famous incidents one need to know. And next, one of the famous incidents is Mothers of Manipur incident. What happened here? And young age woman or lady was brutally raped by Assam Rifles personnel. So to wake up the Indian government and to wake up the world to look towards the northeast India, many mothers of Manipur who were moved by the brutality of the rape and death of the lady, they came in front of the Assam Rifles office and they stripped themselves, where women considered it very bad, or they even went to such an extent they stripped themselves and they protested like this in front of the Assam Rifles office, saying the placard that Indian Army raped us, where it was not army but Assam Rifles which they did. Just to make the world look there, they have protested like this. And it was one of the successful protests where government later led to the committee which had to look into the sexual assaults committed by the armed people in the region. Next, let's see the status of Armed Forces Special Power Act in various states of India. In India, implemented in whole state. Where exactly this AFSPA is implemented as a whole? It is implemented in the whole in Assam, Nagaland, and it is also implemented in whole in the region of Manipur, except the municipal region of Manipal, which contains 7 assembly constituencies. Whole of Assam, Nagaland are disturbed areas. Okay, it has been consistently extended for 6 months. The whole of Manipur, while exception of Impal municipal area, has been notified by the state government from 1 year, December 2020. Next, in Mizoram, the insurgency came to a deadlock in the year 1986, when the state government had a deal with the Indian government and insurgent group gave up their arms. But still, though it is not exactly in force in AFSPA is not exactly in force in Manipur, but there is no provision saying that it has been repealed in the region of Manipur also. But it was clearly mentioned that it was removed from the other regions that I will discuss in the next slide. But here AFSPA is promulgated partially in 3 districts of Arunachal Pradesh. Here you can see the 3 districts. Those are Tirap, Longding and Changlang areas. Tirap, Longding and Changlap areas, which border especially the Indo-Myanmar border and also border the Nagaland. You see here, this is our Nagaland. These 3 districts are very near to Nagaland and Assam. So why exactly only these 3 districts is because this region, this Tri-Junction region and this region in Assam has been a hub or a ground or breeding center for most of the insurgent groups, and because of lot of atrocities, organized crimes, kidnapping happening in these areas, government thought it is very important to station the armed forces in this region to protect the civilians from these insurgencies happening in the region. So kidnap, extortion, killing, okay, all this they want to stop, especially because of the insurgent groups of Nagaland which are breeding here and Ulfa groups also. Next, where this act has been repealed, as I discussed little bit while, similar to that, this act was repealed in the state of Tripura and Meghalaya. In Meghalaya, though this act was only till the 20-kilometer radius, 20-kilometer radius from the border of the Assam, it was later repealed in the year 2018. And in Tripura, it was the first state to get repealed from the AFSPA in the northeast region in 2015 after being in force since 1997. It is considered the most peaceful state in the northeast region to this day. Let's see some of the important statistics which also very important for you to write a beautiful answer which shows whether the AFSPA is brutal or non-brutal, whatever it is. So when it comes to statistics, you see how many civilians were dead, how many normal civilians, how many extremists died, how many extremists gave away their arms. Let's see. Civilians killed in Assam, there were 11 killed, in Nagaland there were 14 and in Manipur there were 9, because these are the 3 major areas where AFSPA is under force. In a total, there were around 33 civilians killed in the just 1 year in 2021 till to the date because of 7 killings, 14 killings which happened in Mon districts of Nagaland. When you see how many security personnel were killed in the same year, only 8. And how many insurgent groups, extremists were killed? 39. And extremist surrender is 1400. This surrender is especially due to the ameliorative measures which were brought in on the table of talks from the central government, like such as giving extra budgetary supports and all those things. So you can see, one can observe, my friend, when it comes to the loss of extremists and civilian lives, there are more civilians who died when compared to armed forces personnel, just with the mere suspicion, and this should never happen. And you can see in 2019-20 there was a decreased trend, but this is a skyrocket increase which should never happen. So these statistics are very important, my friends. You have to analyze these statistics, just pass and note down, so that you can analyze yourself whether it has been increasing, decreasing or something other happening in that region. Why exactly it is happening also. Conclude yourself by linking it with cross-border terrorism, some international relations issues happening in the neighborhood state also. Now coming to how exactly you can make this AFSPA to a way forward situation. What exactly are supporting arguments for AFSPA and opposing argument for AFSPA, we will see in this class. So before going for supporting and opposing, so AFSPA has been recently extended for 6 more months. It recently, that is in January, from January till 6 more months they have extended in the region of Nagaland, because there was a skirmish between civilians. There was not exactly a skirmish, the armed personnel, because of the lack of intelligence gathering, exact intelligence gathering. They attacked on the civilians who were returning from working in the mine. So around 6 civilians were killed in the incidents. 6 villagers returning from coal mine were killed. So then what happens? All the villagers got angry and they started attacking the vehicles of Assam Rifles. And because of this attack, during this attack, the Assam Rifles have to counter-attack and save themselves because most of their personnel were also killed in this attack. So in that attack, 7 to 8 more people were killed. Okay. So then what happened? Because of this rising protest, where each and every northeastern state where AFSPA is in force gave their voice in support to Nagaland to repeal the AFSPA in Nagaland, but the center was not ready to repeal the AFSPA. Why it was not ready? We'll discuss in detail in the next slide, which is going to come. So as I told you, there are major constitutional rights and also major fundamental rights which are under lapse because of this AFSPA. Let's discuss about them. You see, fundamental right of peaceful assembly under Article 19, because under AFSPA that more than 5 people can assemble at a time in their place in a public area. So this is against Article 19. Also it is something like Section 144. All the time it is imposed in this region. And right to respect on conviction of offences, that any person can be arrested without any warrant. And the time period in which an arrested person should be submitted in the court is not clearly mentioned, which only says that in no time he should be put in front of the court and should be surrendered to the state police forces. It is only mentioned, but the time period is not exactly mentioned. This also brings a issue with Article 20, and right to life and personal liberty, where a person can be shooted. This is under infringement. And preventive detention, where a person can be detained with mere suspicion, and time period is also not provided how long this person can be detained. There is no constitutional remedies, because one cannot go and give a complaint on armed personnel. He can merely skip his duties by saying that was my duty and I perform my duties. He can merely skip that case by simply saying that this is under AFSPA, I have done my duties. So violation of right to equality is also there. When compared to the mainland of India, this region has been continuously under surveillance under armed forces, and this brings a major challenge of investment in the region, and they claim that we are not considered equal to the people in the mainland. So what exactly are the arguments in support for Armed Forces Special Power Act? Let's see that. Arguments for AFSPA. Because if AFSPA is not there, that is, if protection is not given to the armed people in the region who are there to control the insurgency, they feel very low, and there might be continuous fake cases by forcing the civilians through insurgent groups. For example, let me say you, if I am an insurgent, I might force a civilian give a fake complaint on this army personnel because he is strict and he might cause a threat to my insurgent group. So then what happens, my friends? Such a cases pile up, and it restricts the duty of a armed personnel. So that is one of required to deal with terrorists and insurgents whose stated objective is breaking up the country. AFSPA is necessary, and it is also necessary because it should not be demoralizing for the armed personnel. Without AFSPA, militias may motive and threaten locals to file fake lawsuits. Army require minimum safeguards from legal harassment and empowerment of its officers to decide on employment of minimum force that is considered essential, because they need freedom. Without freedom, the army can't control the insurgency in that region, because the terrain itself, my friends, when you even look at the geography of the northeast, it is highly hilly terrain. Hilly terrain, high rainfall, malaria is in prevalence, high amount of mosquitoes, my friends. And you can also say it is high jungle warfare also, or forest, you can say, because you see on an average 70% almost 70% of the geographical area of these northeastern states is covered by forest region. You can say 60 to 70% in an average. Because of this hilly terrain, forest regions, there can be easy guerrilla type of warfare which is going on. So because of all these hardships, army needs some protection. So AFSPA is necessary to maintain law and order in disturbed areas, otherwise things will go haywire, and the law also discusses the advancement of terrorist activities in these areas. Even terrorist activities might also increase because of its border nature with Myanmar, which is very near to major opium trading area, that is Golden Triangle. Next, arguments against AFSPA. So why I want AFSPA not to be there? Because of the abuses committed by the armed forces to the power which was accorded to them from the Act. So what exactly happened? It has been alleged that immunity granted by Act has led to the armed forces to misuse the powers, and these commit offences like sexual assault and encounters. Justice Santosh Hegde committee to investigate the fake encounters in Manipur described it as a symbol of oppression. What is Justice Santosh Hegde committee said? They said this act is a draconian, or it said this act is a symbol of oppression. So it also increases terrorism, because extreme force you put, because without the governance happening and force happening continuously, the civilians may turn towards the terrorists for safe havens. It has failed to contain the terrorism and restore the normalcy in the disturbed areas, as number of armed groups has gone up after the act was established. Many even uphold it responsible for spiraling violence in the area, because there was no increase in the armed personnel, because even in 2021 you can see around 1400 insurgents or extremists have surrendered. This shows the true nature. Even after 50 plus years, almost 60 years of this act, there is no look that insurgency has been dying. So why exactly we win this law? Threat to fundamental rights, as I told you previously, clearly explained on that. Threat also to the human rights violation, diminishes credibility of the democracy. Okay, that is people's delusionment. Always they see that we are in a democracy country and democracy is nothing but force. Then they have delusion and they slowly want to move towards the communist China. This is also a dangerous thing. Excessive use of force and using it despite having other options. We have many options, man. Like we can also promulgate a national emergency under president rule or some sort of emergency. We can use the state police force. We can use those powers. We can also repeal this law and we can put similar provisions in some other acts. All this. Why you want to use this? The decision of the government to declare a particular area as disturbed area cannot be challenged in any court. Very important point. Please note it down. One cannot go to the court and ask that they have been declared this area as disturbed area in a wrong process. So please declare this area as a peaceful area. No one can go to court. Hence, several cases of human rights violation go unnoticed. So let's see some of the important committees, what they have recommended on AFSPA. One of the most important committees is Justice Jeevan Reddy Committee, which was a 3-member committee, I hope so. In the year 2004 it was there, and in 2005 it gave its recommendations. The committee has recommended a complete repeal of this law. Justice Jeevan Reddy Committee said, just repeal this law, we won't want this law anymore. The act is a symbol of hate, oppression and instrument of high-handedness. The committee said the act is a symbol of hate, oppression and instrument of high-handedness. Next, what are the major recommendations it gave? It said that most of these provisions of AFSPA should be included in the UAP Act, in the Unlawful Activities Prevention Act 1967 by amending that act. Should be modified to specify powers of armed forces. They also said you amend the UAP Act in such a way that paramilitary forces and armed forces powers are clearly mentioned in that law. Grievance redressal cells should be provided in each and every district where AFSPA is in force or disturbed areas is in force, so that grievance redressal is fast. In case of situation no warrants, the state government may request union government to deploy army for not more than 6 months. It also said there should be no case. It only should continue for 6 months. If you want to continue for more than 6 months, if central government declares an area to be a disturbed area, it should be only for 6 months. If more than for 6 months, then the parliament approval should be needed, as in the case of national emergency. So see, by reviewed after every 6 months, and parliament approval should be sought for extending the deployment. So even the second ARC, the second Administrative Reforms Commission, in its 5th report on public order has even committed that this Armed Forces Special Power Act should be repealed. But there is no action still today which was taken based upon these recommendations. We'll also see some important observations made by Supreme Court eventually all these years. The Supreme Court in its judgment has said that AFSPA should be only used to supplement the civilian authority and not to supplant the same by putting in place the military administration. They said it is only supplement but not supplant, that is, you cannot remove the civilian and take over as a military authoritarianship. The section 6 of AFSPA, which preludes any prosecution, suit or legal proceeding against personnel of security forces is no longer valid if the death of civilians is unjustified. It said you can't do whatever you want, you can't just kill a person and said I killed on the basis of this law. You must be responsible for that killing and one should justify why he has killed. So the blanket provision that security personnel no longer can be credible for their acts has been removed by the Supreme Court in its judgment. Use of excessive and arbitrary force is unreasonable to a person, a criminal, insurgent, terrorist and militia. It said you cannot use just by saying that he is a criminal, excessive force on that person. It is wrong. Every death caused by armed forces in disturbed area, be it of common personnel, criminal, should be thoroughly inquired. Supreme Court also said every death should be thoroughly inquired. Some other committees also have given similar recommendation eventually years. That is, one of them is Punchi Commission on Center-State Relations held that the constitutional power of governor to declare area to be disturbed area to be restricted and reviewed every 3 months. Punchi Commission directly said just 3 months, whereas Justice Jeevan Reddy Committee said 6 months. Okay, 6 months. Even the Justice Verma Committee of 2013 suggests that armed personnel shall be subjected to ordinary law in case of sexual violence against women. Why, my friends? Because most of all the cases which are against the armed person will go to the court martial or military court. Military court. Even if the person has been declared that he has committed that, he can go to High Court to challenge the military court decision. High Court to challenge the military court decision. So this procedure is very long and the armed person can easily skip just because he has been not being applied under the ordinary laws. So Justice Verma Committee said just apply the ordinary laws for even the armed personnel who have committed sexual offences. So what is the way ahead? All we discussed, the argument for, against, but we want the AFSPA to be removed one or other day. We want that people of the Northeast region to be peaceful and happy and prosperous and enjoy all the fundamental rights enjoyed by the mainland of India people. How? Then it is, my friends, you can't just repeal AFSPA in a day. It should be a progressive way by developing that region, by giving better inputs and education on all those things will be one of the way forward. See, rooting out AFSPA totally might create an atmosphere of chaos and chances of increasing of terrorism and insurgent groups may form proxy governments and readily exploit the people, which we see majorly in the region of Nagaland where parallel governments exist. The ministry is waiting for the state government to have an idea, want to share the idea. We have to amend the AFSPA, basic thing, to delist the offences like sexual offence, etc. from trying them out on the state and national laws. One of the important thing what we can do is Just amend the AFSPA saying that if an armed person commits sexual offences or violence against women, he can be dismissed and can be prosecuted under the laws framed by the state government and the national government or CRPC procedure. Next, slowly phase out the AFSPA based on the threat perception from such areas and strengthen the local police. Because just of the weakness of the state police, lack of intelligence gathering or lack of number of personnel in the state police and lack of equipment with them, the army people come into play. Just by strengthening them and supporting them with infrastructure, you can repeal AFSPA slowly. Proactive role by local government towards real development, especially social sectors. In areas where AFSPA exists, having a robust judicial mechanism, withering army to weed out the elements from within who indulge in such violation for promotional awards. They said strengthen the judiciary in this area because most of the army personnel just commit these adventurous task of killing people and attacking on people just to get awards. So this should be not be anymore. By strengthening the judiciary, you can make this possible. It also says increase the strength of the Panchayat Raj institutions or so that they can develop in the local areas. Under one more way forward, because constitution already has national emergency presidential rule. Why can't you just promulgate that emergency? Why can't you control that areas by just using this act and amending repealing the Armed Forces Special Power Act and amending the eventual laws such as UAPA and providing the exact powers? Because most of the actions which are taken under the AFSPA Act have been already in existence under CRPC codes. So having such a draconian law at once is not very healthy for the Indian democracy. So my friends, we here come to an end of this class. Let's see few of the model mains and prelims questions which come from this topic. When it comes to a model mains question, let's see a previous year question which came in the year 2015, which says human rights activist, it directly says, activists constantly highlight the view that Armed Forces Special Power Act 1958 is a draconian act leading to a case of human rights abuse and security forces. This is a statement given. Statement already says this is a draconian law, there is a human rights abuse. What sections of AFSPA are opposed by activists? What sections? What sections are those? Critically evaluate and the requirement with reference to the view held by the apex court. Okay, requirements of the view held by the apex court. As I showed you that the Supreme Court has said that sexual offences should be come into the sexual offences should be considered and should be considered as a normal laws, and it also said that the armed forces personnel cannot have a blanket protection. All those recommendations you need to write. So this question has three parts, my friends. Remember, whenever you see a question, try to divide that question. First thing is you need to do in this question is justify this part. Justify this statement saying that there is a abuse of human forces, it is a draconian law by few examples. Either say the recent Mon incidents, either you can say some other incidences like Mothers of Manipur, Irom Shermila incident, whatever you want just by providing. And this is the second part. What sections of AFSPA? Major sections are section 3, section 4, section 5, section 6. Section 6 calls about the immunity. Section 4 gives the power of armed forces to kill a person. Section 3 gives to declare disturbed areas act which does not have definition. These three. Okay, and then he is asking, critically evaluate the requirement with reference to the apex court views. What are the apex court views? I have said you in the class. Please go back to the video, look at the slide and try to answer this question, and please paste your answer in the comment section so that most of the aspirants can look at your answer and correct it. And even we here at Telugu One Academy will evaluate few of your answers to help you. Next, one more model question which you can try to write. What is Armed Forces Special Power Act? Critically comment on its implications and provide way forward. The last point which I have discussed is way forward for you, my friends. That is amend AFSPA, repeal AFSPA, how you can repeal AFSPA, strengthening the state police forces, all those points. Okay, try to answer this. Let's try to answer a model prelims question. Though internal security is the mains related syllabus topic, there is no say that this is never gonna come in the prelims, because internal security is a very dynamic topic and is a part and parcel of your current affairs. So you might expect 1 to 2 questions from internal security. So let's see one of the model question. Which of the following statements is or are correct? He is asking you. Only center can declare particular area as disturbed area under AFSPA. Your first statement. The decision of the government to declare a particular area as disturbed cannot be challenged in court. These 2 points I have discussed in the whole slide or whole class today. One thing, my friends, I have continuously said you that it was first the governor of the state who can declare an area as disturbed area. Later it was given to the central government by an amendment in 1972, where both governor and the central government can declare an area to be a disturbed area. So eventually or exactly, statement number 1 is wrong. Statement number 1 is wrong. Even in the slide I have said you that after declaring an area to be a disturbed area, no person can approach the court to say that this area has been declared disturbed area illegally or not by a procedure. No one can go and question, and even judiciary cannot take up that case. So your statement 2 is absolutely correct. Now you see, please, very very important, whenever one person is attending his prelims, one should be very careful, not just by these 2. He should also be careful here also. So he is asking you here, what did he ask you? Is it correct or incorrect? Whether he asked you correct answer or incorrect answer. He asked you only for correct answer, then your answer with option which is correct is only 2, your answer will be option B, only 2. Similarly, let's see. Next model question. Consider the following statements related to AFSPA. Power to declare an area to be a disturbed area was conferred only upon the state government. Just now we have saw. So this is wrong. State government has authority to reprimand or prosecute those members of armed forces that commit human rights violations against citizens. Clearly mentioned under the section 6 of Armed Forces Special Power Act, which says no person can be prosecuted just for duties committed under the AFSPA. Then how can a state government do? This is also wrong. Declaration of disturbed status should be reviewed every 6 months. Wonderful, it is very good, because it was recommended by Justice Jeevan Reddy Committee, and it was even recommended by the Punchi Committee to review it in every 3 months. But my friends, it is not provided in the Armed Forces Special Power Act of 1958. So even this statement is wrong. What he is asking you, please note it down. Which of the statements are incorrect, he is asking. What he is asking you? He is asking you which statements are incorrect. Then your answer should be option D, all the given statements are incorrect, where nowhere in AFSPA it is mentioned that this declaration should be reviewed every 6 months. So my friends, here we come to the end of this session. So thank you for watching our video. This is Nikhil from Telugu One Academy. Thank you.